What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. I hope you guys are having a great start to your week. I've got some good court clips. I've got two hearings. Both of them are a little bit longer, and one's out in North Dakota, and then one's in Kansas. And then we're gonna finish with some off the record funny conversation with Judge Perkins at the end. All right, first one, Judge Thornton out of North Dakota. This is a court I found, I don't know, probably 2 or 3 months ago, and not a lot happens in North Dakota. I know, surprising, right? But not a lot happens, at least in the courts. But I do watch them every day because I want to share these clips because sometimes you get a good one. And this is a good one. This defendant just got divorced. Well, I don't know if it was just got divorced, but he's an older gentleman, and I called him Grandpa. Just I don't know, just because I did. And yeah, it's kind of funny, kind of sad at the same time. Let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Execution. First case the court's going to take up on the 9 o'clock docket is a bench warrant in Milbrandt versus Milbrandt, file 37-2021 DM35. In this case, there was a bench warrant issued in a divorce matter. Judgment was entered on January 11, 2022. An amended judgment was entered June 8, 2022. There was an application for an order to show cause. An order to show cause.
Welcome, Sammy. Glad that you made it. Glad you're here.
Entered on July 12, 2022. There was an order to show cause hearing before Judge Crum on November 23, 2022. There was a motion for contempt. And then an order for dismissal or withdrawal of the order to show cause, filed in 2023. Then there was another application for order to show cause entered on August 31, 2023. That hearing was set. There was another order to show cause hearing on October 10, 2023 in front of Judge Crum. At that time, the court found the defendant in contempt and issued an order finding the defendant in contempt on 10/18/2023 as record index 155. There was another order to show cause application filed in February of 2024. There was another order to show cause hearing March 21, 2024. Again, on March 26, 2024, the court found the defendant in contempt. His record index 183 demonstrates. Since then, this is one where it appears, if I recall correctly, this is one where the court received an email that the defendant is now at an assisted living home in Enderlin and was trying to apply for some financial assistance and needed to clear the warrant. The court notes neither the plaintiff nor the defendant appears. Oh, is that? Okay. So, sir, come forward here. What's that? Oh, okay.
And the defendant rolls it. Yep, that's the defendant. Yeah, he's looking young and spry, right? Held in contempt after a divorce hearing. Oh man, I wish we could hear the details on the divorce hearing and why he was held in contempt. All we know is he didn't follow the orders. At least that's all I remember. Maybe they go into details. I don't know. And yeah, I know the judge's voice is very soothing and it could put you to sleep. But it's the case is about to get interesting. It is. It's again, it's funny and sad at the same time.
All right. So after the court explained all of that, it appears as though Rita Milbrandt is present without counsel. Or
Yeah, this defendant absolutely rolls for his rights because he can't stand for his rights. Rolls for his rights. Get it? Haha, I know that was bad. That was bad. My humor though.
Milbrandt is present without counsel. Mr. Milbrandt, did you hear?
For everyone that's coming in, no, this is not a divorce case. Well, the underlying case is a divorce case, but the defendant, the man here, was held in contempt for not doing something he was supposed to do for the divorce, and that is his ex-wife sitting at the table. He is sitting in his comfortable wheelchair and his best pair of sweatpants. He's just wanting to live the rest of his life. Like he I will tell you this. He gives no shits about being in court. He really doesn't.
The court explain what your rights are?
Basically, I guess.
Okay, well, I read them to you twice while you were sitting here. Do you recall me explaining those rights?
I have memory loss. I have short-term memory loss. That's why I've been on disability since I was 56.
Okay. And so, do you know why we're here?
I think my ex-wife wants more money, or wants money.
Okay, well, the court issued a warrant after you were held in contempt twice. So let me read through the last contempt order.
Well, I don't always get all my mail. I was in assisted living, and then I was in the hospital, and then I was in a nursing home. So I don't always get all my mail that goes to my daughter.
Well, the issue was served. There was a notice of entry of order that was served on you. And it was served at an address in Fargo, 4502 37th Avenue South, apartment 168 in Fargo.
That was assisted living.
Okay. So that didn't go to your daughter, that went to the assisted living facility, and you would have gotten that, right?
Maybe, I don't know.
Okay. So first things first, the court's going to quash the warrant.
Pardon?
The first things first, there's a warrant outstanding for your arrest, and I'm going to quash that warrant right now
Thank you.
because you appeared in court.
Okay.
So that doesn't solve the entire problem, though. So give me a few moments here. This is a 7-page document. I need to read through it real quick.
Yeah.
So give me a minute.
I want to add my daughter got me out
So-
of it.
Give me a few minutes here, okay?
Read it out loud, Judge. We want to know the details. At least summarize it when you're done. Oh, yeah, I saw that. I saw that he sent everyone to Artie. I love Artie. He's got a great channel. Um, I didn't know that he ended. That's so hard. It's so hard to plan. When you see somebody like, oh, I haven't rated them in a while, I'm gonna raid them, and then the second you raid, and then they end the stream, it's like, oh, thanks for coming, I'm just finishing. Yeah, that's always tough. It's always tough. You can't plan for that. But everyone that wasn't Biggin, thank you for coming over. I don't. I highly doubt Biggin's here, but happy birthday, Biggin! Biggin's birthday today. Um. Anyways, for everyone that just came in, this is a contempt hearing for the gentleman in the wheelchair. His ex-wife is sitting at the table next to him. He did something. We don't know, but he did something to earn contempt times two. So he did two things. He failed to do two things. Earned himself contempt twice, and now he's in court because there was a bench warrant put out for him. Yeah, don't think he was rolling very fast to get away from this bench warrant. I'm glad he showed up. MB, that's hilarious. Wheels, come on. I bet this guy's a riot. You should just wait. I don't want to spoil it, but some of the things he says at the end of this hearing they're funny. All right, how much more dead time do we have? I don't want to fast forward it, but it's been about 30 seconds. Judge did say there was 7 pages that he's reading through. Let's see how fast of a reader he is.
So, Mr. Milbrandt, I'm looking at the last order from the court. The last order of the court had required you to distribute certain funds to your ex-wife. Those funds, as of the date of the judgment that the district court entered on 3/25/2024, so 9 or 10 months ago, there was a requirement that you pay $10,000 in accrued sanctions, $8,900 for a deficit incurred because you were ordered to distribute part of your pension and disability income, and reasonable attorney's fees of about $2,700 for a total money judgment in the amount of $21,597.46. So 21,597.46. And that judgment is accruing interest at the rate of 11.5% per year. The court issued the warrant in 2023 and several times indicated that the judge intended to hold you in jail until you paid the money that you were ordered to pay.
Where am I going to get the money if I don't have it?
Well, that was part of the problem, is it was supposed to be distributed from your pension account, and the only person that can do that is you, unless you have a guardian or conservator that's responsible for doing your
But
financial.
I don't have a pension account.
Okay. So I wasn't present when things were testified about. All I'm doing is I'm reading the court's order. That was the previous judge's findings. So his order asks me to put you in jail for up to 6 months.
Okay. Is there going to be somebody there to give me my medication?
So the jail can take care of that. I don't have a lot of options here because I can't just undo what the other judge did.
Okay.
And so you hold the keys to the jail as soon as you turn over what you were supposed to turn over in those previous cases.
I don't have it though.
Well, those are things that ultimately, I don't know what evidence was presented at these 2 previous hearings.
The only thing I have is Social Security and disability income. And the disability income is protected by law.
Well, it looks like Judge Narum found otherwise.
Okay,
So, I mean, it is what it is. So I'm going to enforce Judge Narum's order.
you're gonna put me in jail?
Well, I didn't do that. Judge Narum did.
Where do I
But,
go to jail at?
well, it'll either be Barnes County, Stutzman County, or Richland County. I don't know. But you'll be there until you either pay the money or 6 months expire.
I
So,
don't have the money, so let's go.
all right. Well, that resolves the case. I was hoping not to put you in jail, sir, but ultimately Judge Narum found.
What are the options
So what are the options?
besides going to jail? If I don't have the money,
Yeah. So ultimately, Judge Narum concluded that you did and that you have been in
and then he
continuous
did it one
contempt.
time, but I paid it to the nursing home or to the assisted living. That's 60,000 a year.
Well, I understand that, sir, but ultimately,
And I was in there a year and a half. So that's $90,000 right there.
yeah. Well, if it would have been paid on time, it wouldn't have been an issue. That's what Judge Narum is saying. So those are the options for the court. It's to hold you in, you've already been found in contempt twice. I'm not making another contempt finding. Ultimately, I'm sure this isn't what the nursing home wanted. The jail might write to the court and say, I can't, they may or may not take you in light of your health conditions, sir. Judge Narum again found you in contempt twice, entered the order that you'd be picked up, taken to jail, and held there until you distribute the IRA number, account number 7190.
That's been cashed. That's been cashed in. That's been cashed in.
So you have some legal options. I can't give you legal advice. You'll have some legal options. You might want to ask for a hearing in front of Judge Narum, and you can explain to him what happened, and he can make a decision. But right now, I'm not going to do anything that contravenes his order.
He'll just put me in jail longer.
Well, the statute says he can hold you in jail for up to 6 months.
Okay.
So, but again, you
Do I
hold,
get a TV in jail?
I don't know. And I suppose it'll depend on where you're at. All I'm going to tell you is, I'm just going to enforce Judge Narum's order. And if you take issue with it, there are options for you to appeal. There are options for you to seek relief from judgment. But ultimately, I can't explain to you how to do that. I can just tell you that you might have some options. And again, the jail may or may not take you, but I'm going to order you into custody because that's what Judge Narum and his order requires. And ordinarily, I have to follow what other judges have done in the case.
So this is all because my wife wants more money.
Well, I don't know what the facts are, sir. All I know is this is the order that's been found. You had 2 hearings where you had an opportunity to present evidence. And after those 2 hearings, Judge Narum found you in contempt not once but twice. And so it doesn't leave me a lot of options. His findings are clear. So you'll be taken into custody and they'll transport you, and the jail will let me know whether they want to keep you or not.
What if they don't?
And we'll have to have a hearing. But ultimately, it likely will be reassigned to Judge Narum because Judge Narum made the findings. And I'm just not
So
comfortable
where do I go in the meantime?
with the sheriff's deputies.
So that means in the county jail.
This is a county sentence or a county finding. You don't go to prison for contempt. Anything else, Miss Milbrand?
Well, you just said I was going to jail.
Jail and prison is different. Those are different things. So jail is county jail. Prison is state imprisonment. And so the The statute allows you to be held in custody for a maximum period of 6 months. And that maximum period starts when you go.
When do I go?
Now,
Pardon?
now. And so, or if you're able to satisfy the judgment and take care of things sooner, ultimately, sir, you hold the keys to the kingdom. So
Judgment is how much?
the judgment, at least as of the date, May 25, 20, or March 25, 2024, was just shy of $21,600. And it's been accruing interest at 11.5% since.
I don't think.
I don't know. He may have had an attorney for the divorce proceeding, but this is contempt. Contempt of court for not paying for his divorce. So I don't think you get a public defender for this because it's technically family law still. He is, going to jail though, so maybe he would qualify, but I don't know. I don't know how that would work. But I don't know if I've ever seen someone go to jail for not paying. Well, I guess I have. Child support is kind of the same thing. Not really, but it kind of is. I don't know if I've seen people in jail for not paying like alimony type of things, but I've seen court proceedings over them. So I guess yeah, it happens. Yeah, it is. It is sad. It's kind of sad. I just like his attitude though. His comments he makes about the food and yeah. All right, let's finish this one up.
There
There are two judgments,
Yeah, I was just looking at the one
the last one.
that Judge Narum signed on March 25, 2024. So there was a money judgment that was entered before as well, record index 188. That one reflects the $21,597.46.
How about down payment would you take?
That's not how it works.
Oh,
So it's not something that I'm willing to renegotiate with you. I don't negotiate. I can't. So those were Judge Narum's findings. Found you in contempt. He wants you held in custody until you either pay or 6 months expires, whichever comes first.
how's the food?
I think that really depends on where you go. So I can tell you, when I was a defense lawyer, some places feed you better than others.
If the food's decent and I get a TV, it really makes a difference where I'm at.
Well, that's a decision you make, sir. You hold the keys to the jail.
What about my medication?
The jail will give you required medication. Anything else, Miss Milbrand?
No? Thanks, Rita.
All right. Anything else, Mr. Milbrand?
No.
With that, we're adjourned.
I want to thank my ex-wife for bringing this down on me.
All right. Yeah, he had to get that last little jab in on his ex-wife. I would like to thank my ex-wife for bringing this down on me. He owes $21,000 to his ex-wife. I mean, look at him. Look at him. He's in a wheelchair, collecting Social Security. How are you going to get $21,000 from that guy? Maybe he has it. Maybe he has it and just not going to pay her. How does that work? MB, I don't know if you'll even know the answer to this, but if he owes her, money from the divorce, they went through the details of what it was, but he owes her 21,000. If he has the money, he just decided not to pay her, and then he passes away, and in his will he leaves his all of his money to his daughter. I think he said he had a daughter. Does she can she claim that $21,000 from the daughter? I wonder. I'm guessing that she could sue for it. I don't know if she would win, but she could always sue for it. All right, let's do this real quick. Sashina, 14 months. Sashina, you were one of the first. I know I've said this before, but you were, I don't know. Heather was the first member. You were, I don't know, second, third. You were top five. Um, 14 months. That is awesome, Sashina. Thank you so much. MB, I know you're not a new member. I don't know what happened, MB, but thank you so much for coming back. I don't know. YouTube's glitching again, but MB, thank you so much. And say my name, say my name. Oh, it's Sly's fault. Cinnamon prostitute cat. All right, I win. I win. You are now known as Cinnamon, my favorite prostitute cat. Thank you so much, Cheshire Cat. I do appreciate it. Also, let's see, MB again with the PayPal. Thank you so much, MB, and you are welcome. Thank you so much for hanging out tonight, MB. I do appreciate it. All right, let's move on. We are moving on. Let's change topics. Let's change states. We're gonna leave North Dakota. We're going down to Kansas. This is Judge Crum. We have a pro se that has, I don't know. I've covered this guy at least once before. He's weird. He's just weird. He's borderline a sovereign citizen. Yeah, we're gonna keep it at that. Let's go. Oh, Lone Wolf's here. Lone Wolf covered this yesterday. Was it yesterday or this morning? I actually don't remember. The hearing happened yesterday. I don't remember. I saw Lone Wolf covered this already, so you may have seen this before, but it's still good. Let's go.
Good morning.
Good morning.
All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus James Brent Watts, case number 22 CR 83. Would counsel announce appearances, please?
Cheryl Pierce on behalf of the state.
Your Honor, James Watts has standby counsel for James B. Watts, who is acting pro se.
All right. That's correct. James Brent Watts is appearing pro se. He's representing himself. I scheduled this hearing today to take up several motions that have been filed by defendant Watts. I'm just going to go through these in the order that they appear in the court file. The first one is a motion for continuance of the February 4th trial and the January 31st pretrial conference. Defendant Watts, are you still seeking a continuance of the upcoming trial?
Yeah, I have had no access to evidence. James R. Watts played a trick. He brought a phone number by me and he knows dang well that arms list won't answer a collect call. I wanted addresses and phone numbers. Now the phone numbers, if I went to Larned, I could use those up there. But anyway, I can't use them here. But anyway, I've had no access to get anything. Nothing's changed since the continuance was granted last time. I haven't even got glasses. So I can't see. And then they've also been refusing medical. The dizziness and stuff from the negative energy being inflicted to me is getting worse. But anyway, no, I have not got access to anything. I haven't even got the transcript. I wanted a copy of the transcript to go over. I need a copy of my grandfather's will. All firearms were left to me. So Dad saying that firearms on there were left to him. No, and all those firearms are newer than could possibly be left on that will. They're to be used.
Well, you're kind of jumping around a little bit, so let's come back to that motion. One of the other motions that you filed is the motion for, it's titled Motion for My Required Evidence of a Copy of My Grandfather Brent Bollin's Will, listing what was all left to me, including all firearms. Where is this will located?
My parents would have a copy of it. Or maybe even several, I don't know. It would be there, and what do they keep them at court? Is it, well, I don't know. They keep them somewhere in the county building, I thought too. But anyway,
Was this a will that was admitted through a probate estate here in Butler County?
it set up a trust for me and everything. Yeah, it was an official will. And all firearms were left to me. They've always been left to me. Nothing in the way of firearms was left to Dad. I don't know what all was left to Dad, but
Well,
left to him.
I'm not sure what power the court has to produce a copy of this will when we don't know where it is.
Oh, my parents have a copy. They absolutely have a copy somewhere. I don't know where they put it. It'd be possibly in the file cabinet downstairs. Probably that's where it's at. They have a copy. I think I had one years ago, but everything's gotten changed around. I mean, they've switched houses and everything else. A lot of stuff's been thrown away. So I don't know where my copy was. I absolutely had one sent to me and everything. Went through it, and then they had one.
Judge,
Go ahead, Ms. Pierce.
I believe that Mr. and Mrs. James B. Watts' mom and dad have inquired into the assistance of Mr. Gail Jensen. I notice he's not here. I don't know if that has been information that's been provided to Mr. Watts, James R. Watts. But some of what the defendant is asking for might be like the will, those kinds of things might be, we might get assistance from Mr. Jensen if in fact there is the ability to get it. I don't know anything about it. It's kind of odd that Mr. Defendant hasn't asked his parents for it. I'm sure they would be willing to provide that, but I don't think that the court has, no court nor do the state have the authority to subpoena that or to get that because it's not part of this case. But as I said, I think we've all kind of went way above and beyond in trying to assist the defendant in getting everything he needs. And I think that Mr. Jensen may be able to assist if in fact Mr. Watts's parents have in fact hired them to assist. But again, he's not here today. So, and I don't know if that's because he didn't know about this hearing because I didn't inform him because I just didn't think about it.
Okay, well, I doubt the court notified him because I had no idea that he may be assisting them in the case. Attorney Watts, do you know anything about this will?
I have not asked my parents because they're defendants here, and I don't think I've asked for stuff in the past. They haven't done nothing. So I've got also my bank records and stuff showing that my cash on hand. I asked for that a long time ago. They haven't done it. They're witnesses in this case for the prosecution. So I don't think, I think they're bothered by getting me anything. So, but stuff has been asked for.
All right, let me address Attorney Watts. Attorney Watts, do you have any knowledge about this will? And you're muted.
I would not, Your Honor.
All right, quick pause before Mr. Watts talks. We've got some membership milestones. Allie T for 8 months. Thank you so much, Allie T. That is awesome. Peepla for the year. Congrats on the year, Peepla. Thank you so much. I do appreciate it. All right. Let's keep going. This one's a struggle to get through sometimes, but the defendant makes it worth it.
I would note that Mr. Watts has a subpoena power. He would have the ability to request a subpoena, and I'm certain that as he's acting pro se, if he would request a subpoena from the court would be glad to grant that. He could subpoena that will and send that subpoena to his parents or his parents' attorney And under that subpoena power, they would have the obligation to provide that document if they have it. He has subpoena power for bank records. He has subpoena power for any of these documents he wishes. He simply has to issue the appropriate subpoena.
Okay, I thought I could just, I'll try that then. I'll get busy and try to subpoena stuff, but
And Defendant Watts, the court doesn't have the authority to order your parents to produce this will. That's something that they can either hand over to you voluntarily or not. But I can't order them to produce the will.
so that's denying me evidence. I mean, if you get a court case going where everybody has the evidence as witnesses against you and they don't want to do it, that's not anything by God at all. No, you get all
As Attorney Watts stated, if you issue a proper subpoena, that may be an avenue from which you could obtain this will. But barring that, I don't have the authority to order your parents to produce this will.
I've had court orders that judges have done for ordering evidence, paperwork from the court records and stuff like that. I don't know anything about not being able to order stuff. But anyway, if I do the subpoenas, I still won't have enough time. There'll still have to be a continuance. I don't think they could possibly, by the time I get it written and get it to them, they take a long time to get me my file stamp caption pages back, several weeks or more. And a lot of stuff I don't even hear back from. I've got that guardianship case that needs to be thrown out because they bluffed it through without me having any knowledge of it and denying everything on it. But anyway, I wasn't even present at the first meeting on the guardianship. Nobody was present for me.
Mr. Watts, that case is in front of a different judge and is not the court today. I'm going to take up another motion that you filed. This one's titled Motion to Take Notice that Attorney James R. Watts visited me at the jail October 10th, 2024, Thursday around 2:15 p.m. and only left a phone number for arms list, which requires a regular phone as businesses will not collect inmate calls from jails. So you've touched on this before. Is there anything else you'd like to say in support of this motion?
Well, I requested addresses and phone numbers. Like I said, if I go to Larner, and that could very well happen again, I can use phone numbers up there. So for me to have them, but here I would have to have the address and enough time to get all correspondence.
Do you have an address, Attorney Watts, to go along with the phone number you've provided him?
I do not, Your Honor. And I think the contact information they have is a phone. Now, they mentioned that they do not collect phone calls. I think Mr. Watts does have some money on his books to be able to make direct calls.
Right now, I don't. I'm having trouble getting money in. My parents have to come to town and put it on the machine up here, and it don't take but $100 a time, and they don't make it to town that much. So money is at times a problem to get, and I don't know for sure I don't have access to lieutenants or anybody of any authority in my pod. I'm in B pod, and have seen the last few days. Thomas has been around because she's on first shift. But anyway, I haven't seen her much at all until recently. I've seen her a couple times, but I'm not sure how I would get money on the phone to make a phone call that way.
And Attorney Watts, you weren't able to locate an address for this outfit?
No, Your Honor. I'm pulling up the website again. Here, the website does not have a physical address. As Your Honor may well know, Arms List is essentially nothing more than essentially a classified ad, an online classified ad service. They are not and do not keep addresses of the advertisers there. All you would have would be an address of a corporate or a website for the for the website. I do not have a physical address.
Okay.
I would have to talk to them to verify they keep no records. Newspapers and everything keep records. I'm sure if the CIA, FBI, or something like that wanted the information, they'd have access to something. So I would have to hear that myself. I don't trust this James R. Watts attorney at all. You know as well as I do in the Bible, attorneys are the worst, evilest, and wickedest there are. They always trick, fool, deceive. I've had no luck with attorneys. I had them up at Chase County allow lies to put me in jail or prison for a couple of years. They aren't worth a damn.
All right. Well, it sounds like Attorney Watts has attempted.
What it sounds like is this guy doesn't like attorneys. I didn't know that, you know, attorneys were specifically cited in the Bible. That's new to me. I didn't know that. I also haven't read the Bible, so all right, let's go. Actually, nope, we're all caught up. Okay, let's go.
To provide you the information regarding that request, Defendant Watts. All right, the next motion I'll address is, it's titled Motion for Court Orders to Involved People that I have access to all of my required evidence for court proceedings and or trial. So you may make argument on that motion at this time.
Well, if you're saying we can't order it, I'll have to see about the subpoenas. I don't. It's going to cost in damages. Oh, I'll want at least $100 billion every word, and it's going to be paid in gold at $5 an ounce. Laugh that up. I determine what the price of gold is. And my cases from Chase County and Butler County before are still going on. They're tripling. Damages are tripling per day. They don't triple every day, but there's damages every day. It's add up every day.
What evidence are you claiming you have not been provided?
I purchased all those dang firearms through my phones, off arms list, and there was only one or two I purchased out of the Wichita Eagle. That bull barrel AR-15 in 2006 probably is probably in there, or might be the first of 2007. That bull barrel AR-15 DPMS was purchased out of the Wichita paper. They would have access to that ad. The rest of them were purchased through arms list. I'm not worried about purchasing firearms. You know as well as I do, there are no laws limiting felons from firearms. In 1930s, they established a National Firearms Act. When the United States went bankrupt, the bankers made them do that. That's stupid bullshit.
Well, Mr. Watts, what evidence?
I never will not have
question?
firearms. And I'm having machine guns. Two of those were fully automatics. I'm not dealing with this at all. So you'll have to execute me or whatever and send me to my angels, and I'll be back in 3 days and we'll just see what happens.
Right. Attorney Watts, have you been able to give Defendant Watts access to the discovery you've received from the state? And you're muted.
Your Honor, I have forwarded the discovery I have received from the state to Mr. Watts. In terms of the records and documents that I've received, they have all been copied and forwarded to Mr. Watts.
And Defendant Watts, have you received copies of that discovery?
Yeah, but we've already been through this. The things I need weren't in there, and they're just playing around. So it's purely satanic. You can tell what all's going on here. I've been through courts before.
Ms. Pierce, has your office provided the discovery that you have to Attorney Watts?
I believe we've provided everything. I did have, I did have, Bobby Albert with the sheriff's office go back and see if we could get some model numbers, serial numbers, things of those nature off of the guns. We have at least 20 guns. I don't know that all 20 of these were involved in the robbery, or if some of them were seized as part of a search warrant. As the court may or may not know, and I'm sure the court probably does, but there was a shooting incident that resulted in a search warrant, and some of these guns may have been taken as a part of that search warrant. I don't, Mr. Watts, the defendant's father did provide a list that was part of the initial discovery, I believe. And so I think that Mr. Attorney Watts did get that. I will resend this list that has the model numbers in case Mr. Watts didn't get that. And he can forward that to the defendant again, so that we make sure that he's got that. But I thought I had emailed that to him, but that may not be. I'll just redo it just so we make sure that we have it. And there's 20 something guns on it. And I have model numbers off of those. So I'll just resend that to Mr. James R. Watts, attorney, and he can forward that to the defendant.
Okay, I don't know anything about a search warrant. I never received any search warrant. Where's that? I never received any information on how things went down after I allowed myself to be shot at the Leon Bank.
Are there search warrants that are part of this case, or is that part of a different case?
It's a different case, Your Honor. Those were conducted through the sheriff's office as well as the KBI as an investigation officer involved shooting.
All right. Well, Defendant Watts, it sounds like the state has provided to your standby counsel the discovery that they have, and he's stated here that he's forwarded to you what he has. So if there's other things that you're wanting to get, obviously you're representing yourself. That makes it a little more difficult to obtain those. We're trying to filter what it is that you're needing, and if it's something that the court can do, we'll look into it. But a lot of this stuff is things that are up to you to try to produce. So
like I said, I'll try the subpoenas. I've never, just for normal evidence, I had evidence delivered to me up at Chase County years ago. Didn't need subpoenas for everything there. But anyway, I'll go ahead and well, my parents aren't asking for stuff. They're old and might forget and don't get around very well at all. So asking them for stuff, I don't know. It takes them. When I asked my mother for the bank record showing my cash on hand, she said it'd take her a long time to get that. She wasn't in the shape to just go down and get it, that it would take her a while to locate the tub they're in, the plastic tote they're in, and then to get them out and get them copied. She said weeks. So I don't know how long it'll take them, but I'll see. She's about the subpoenas too, but it's going to take time. I haven't, like I said, I haven't had, for just this type of evidence, I haven't had to do subpoenas.
right. And the last motion that I have here that I show we have not addressed is a motion for me to be provided a full and accurate transcript of the preliminary hearing and the hearing of all motions prior to the preliminary hearing of October 1st, 2024 by October 25th, 2024 or before. Transcripts aren't generally produced in all cases. As a matter of course, they're expensive. If you have the funds to pay for a transcript, you can obtain those, but they're just not produced for free and given out.
They were at Chase County on my cases up there. I absolutely received preliminary hearing transcripts without paying for them or so on and so forth.
Well, this was a case in which you were present at the preliminary hearing.
Yeah, I'm good. I'm good. I've just been a tidbit distracted for the last couple minutes, but I'm okay, and I am here. I'm yeah. All right, let's go. Good to see you, Wixom.
There are circumstances in which the court will order that a transcript be produced, but it has to be paid for. And if you have the funds to pay for the transcript and want to get it, that's up to you, but I'm not going to order it that it be produced, as it was a hearing that you were present at.
Yeah, but I need it in case people are going to commit perjury or lie, whatever. So I'll have it, and I need to go through it and just see whether it gets transcribed properly.
That brings us back to the motion to continue the trial, and I'm not inclined to grant the continuance of the trial. This case has been ongoing now for a very long time. I think it's the oldest case that I've got on my docket, and it needs to be tried.
We'll be going for jury nullification. I have that right. You're just playing around. I told you before when you did this continuance, I went and get my evidence. You said we would address the motions later. Now you aren't giving me the time to.
We're addressing your motions, Mr. Watts.
Okay, I can't do the subpoenas in the time you're giving me now.
Well, I'm not at this time continuing the trial. We've got another court date, a pretrial conference scheduled. I believe that is January 31st at 9 o'clock. Jury trial is scheduled to begin February the 4th. So,
Your Honor, if I may,
Well, yeah, but that's where Cooligans came from. It's hooligans. I just changed it to Cooligans, so I thought it was clever. So if I change my name, then we lose the play on my name already. So I mean, it'd be just kind of reverting back.
go ahead.
I've mentioned this to Mr. Watts before. If Mr. Watts would provide me, either by letter or I can come out the jail, a specific list of who he wants to subpoena and what documents he seeks, I can put those subpoenas in the appropriate form and send them out.
All right.
You wouldn't get around to them right away, probably.
Well, if you could get to that sooner rather than later, Attorney Watts, that would be appreciated.
I'd like to know also, I forgot to mention, I'd like to know the cost of the transcript too, for that preliminary hearing.
Judge, I have no idea what the cost is. Typically, they're $200 to $400. It depends on the length of the hearing, of course, but I really don't know what it would cost.
Now, my parents, they'll refuse to give me the money to get that, and I have money coming in. So what do I do in that situation? I want a copy of the transcript.
You allow Mr. Watts to represent you and let him get the transcripts if he feels it's needed to get them. That's how you do that. Just saying, just an idea.
Well, I think maybe we can look and see how much it would cost, but again, I think it will, they'd have to look and see how long it was. Would we have a couple hours in the prelim?
I believe so, Judge.
So, all right, Mr. Defendant Watts, are there any other motions you feel that the court has not addressed that you filed?
Oh, you've addressed them satanically, but you've addressed them. But no, it's just denying me evidence. God does not allow that at all. I don't care what the deal is. Nobody gets denied their evidence.
All right, Ms. Pierce,
Either in
anything
jail
else?
or prison or anywhere.
Anything else from the state, Ms. Pierce?
No, Your Honor.
Attorney Watts, anything else?
No, Your Honor. And James, I will be happy to come out to the jail. Let's check calendar here real quick.
You see, I've got cell phones. There was a deal
It'll
on
probably
cell
be
phones.
tomorrow. If you can have a list of the items that you want sought and the persons who would have them, I will attempt to get a subpoena out to do that.
See, what you're going to do is, I'm not going to get the evidence until probably, if I get it at all, the day before trial or something that I can't prepare. It looks like it's jury nullification. I'm just gonna pound that in.
All right. If there's nothing further, we'll be in recess. Thank you.
I like how Judge Crum was just like, nope, I'm done with this. Bye. I love how he's claiming jury nullification before before his trial. Jury nullification. You know, you have to have a jury to even make that, claim, right? Good luck with that, man. Good luck. It's Kansas doesn't usually play their jury trials. They don't. Let's see. Judge Webster has played some bench trials, but I don't think I've ever seen a jury trial from Kansas. So unfortunately, we most likely will not see that. Sad. All right, let's change tune. Before we go, actually, I've got another. Yep, none of your business. 10 months, none of you. Thank you. I am. You're right. I was hiding. No, Heather was messaging me, and I kind of got lost in a quick conversation with her. So I was here, but I was focusing on what she was asking me at the time. Okay, let's move on to the last one. This actually isn't a case. This is Judge Perkins having fun between cases, off the record. It's just a good way to end the stream tonight. It's like 7 or 8 minutes long, so we'll pause it before we head out. But this is Judge Perkins always having fun. So let's go.
Okay, we're just gonna wait on, do we call for special report?
Yes.
We're just gonna wait on a special report to come on in. There is no, I saw that, why not? You're not asking, are you? No, that's what my father used to say, I didn't ask, they didn't say. So therefore, I don't know.
So therefore, I
I didn't ask and they didn't say. Therefore,
find out why.
Mr. Bowman, I was saying earlier today, I would think, well, you know what I'm saying, these Michigan men go around and they talk how, great they are, and, we're Michigan men. That is supposed to be something. I would think that a Michigan man would be more surgical on the Zoom by now than what Mr. I know your basketball coach did not accept that, wouldn't have accepted anything like that on the court.
If it had to do with left-handed layups or left-handed runners and those type of things, and learning to right or make the proper pass, I would have been whatever time needed to be done. Unfortunately, since we are on the record, maybe because I am a Michigan man, and based upon my past experience, I'm a closer. I'm a prima donna lawyer, and the things that are needed for this computer stuff, somebody else has always done it for me. And unfortunately,
Not tag me in on that. I am not making any comments.
I want to tag you in on that because he just admitted on the record he's a prima donna lawyer.
Prima donna lawyer. That's right. Not a good lawyer, not an excellent lawyer, a prima donna lawyer. Very high maintenance. Very high maintenance.
So I'm gonna say this. Hey, tell the city of Detroit to get you a left-handed mouse. That way you can click the button and hey, something? I profess that
that gave me a good laugh today.
I wasn't so up Zoom until I got down here.
Mary Smith, thank you so much for the super chat, and I'm sorry that you had a shit day today. And thank you for hanging out with us, and I'm glad we could give you some laughs. I hope tomorrow is a much better day for you. Thank you for the super chat, Mary.
was on there, and it was all new to me. It was all new to me. But guess what? I'm surgical with it now, Mr. Bone. You see me? You see me? I'm putting people in the breakout rooms when you don't even know that I put you in there.
That's right. That's right. I'm going to say that I have made vast improvements since the first day I walked in here in June. But there is tons of improvement to be surgical. But you know,
I'm taking that line. I'm taking that line from Denzel Washington in Training Day. Alonzo, I'm surgical.
I'm surgical. That's right. But you know, it's when we talk about prima donna lawyering, you know, my skills of cross examination was much like O.J. Simpson. I just cut and run and let him bleed out.
Oh my God, you guys made my day. Oh.
Hey, tune in every day. Mr. Bowman's got something for you every day. Tune in every day.
I was highly depressed until just now.
All right, thank you.
Thank
well,
you.
it's funny though, since we're off the record. You know, Tom Sebron passed, and his funeral was Saturday, and it was a real big thing. And Sebron was at Michigan when I was at Michigan, and his post college career, his after football career was even more impactful as a financial advisor or stockbroker. But Sebron didn't have a whole lot of conscience about what he said. So this is a true story told by a guy named Stephen Ewing, who owns 4 car dealerships across the country. And Ewing and Sebron were part of a group that they go to the Super Bowl every day, every year. Sometimes they had tickets, sometimes they didn't have tickets, sometimes they were in the game, sometimes they were not in the game. And you know, the other hook about being in the Super Bowl is the Super Bowl parties that you go to. And so apparently they were at a Super Bowl party, and Sebron yelled out to Steve Ewing, the car dealer, "Yo, Steve, I got a brother here who needs a Bronco. He hasn't driven a Bronco since 1994. So let's get Al Collins a new car."
So Al Collins was there, and he was thinking about Al Collins getting him a new car, huh? Miss Williams Law says she rolling a Bronco.
You guys are hilarious.
All right. That's about it. There's still about a minute left of this. This all started earlier in the docket because Mr. Bowman, Prosecutor Bowman, has a terrible time putting his mic on mute. And so he's constantly interrupting the court by talking to people walking by his desk. It's never been inappropriate, but you'll hear him just say something to somebody else randomly during someone else's hearing. And Judge Perkins called him out on that earlier in the docket. So it just all kind of came to a head, and they had this little fun back and forth before. I think this is right before the final case of the day, but it was fun, and I wanted to share it. All right, but that's it for the evening, guys. I do appreciate you all being here, hanging out. Thank you all for all the super chats, membership milestones. You guys are awesome, and again, thank you for the PayPal. You're awesome. All right, let's go raid someone. We're probably going to get a lone wolf. He's probably the only one that's going right now. It's the only notification I saw, at least. But let's look real quick. Yep, lone wolf is it. All right, we're set up to go to lone wolf. All right, have a great rest of your evening, everybody. I will see you tomorrow. I have got nothing on my calendar tomorrow, guys. It might be a slow day. I have nothing on the 15th. So we're just gonna have to go, hopefully we get lucky. All right, I will see you tomorrow though. You guys have a great day. Have a great rest of your week if I don't see you. And until next time, bye. Also, go tell Lone Wolf he's awesome. He deserves it. All right, bye everybody.
Oh, man.
But you know something, Miss Gales, I really want to hear. I know Mr. Barry, he kind of keeps this silent about it, and he's listening though. But I really want to hear what Miss Harris has to say. I do.
That summed it up right there when she started laughing.
No, that wasn't Miss Harris. Miss Harris, she's got her mic muted, so she stayed silent. And there she.
I am exercising my right to just be silent. I am going to be silent over here.
Oh,
So I try to tell everybody, they always want to talk. They always want to talk. And an old lawyer told me one time, you know something, if you don't talk, you just might walk. And my father used to say, you got diarrhea of the mouth. You know what I'm saying? And people just can't help but talking. So Miss Harris, she tries to show and lead by example that you just don't say anything sometimes. So that's what
she said. She plead the fifth, huh?
She pleads. All right, let's go back on the record with Miss.
No, I did not. Nice try, Heather. First of all, Heather, I did not miss it. I paused it. There are 3 seconds left of this video, so nice try. Nice try. Hi. All right, you guys are. Words. Heather came in. Now I'm stumbling for my words. I get excited when Heather comes in. All right, I'm out. You guys have a great rest of your night. Bye.